The Supreme Court courtroom was stunned as Justice Amy Coney Barrett leaned forward, her eyes locked intensely on former Florida Attorney General Pam Bondi at the podium below. What had started as standard oral arguments in a pivotal constitutional case had suddenly turned into an unexpected showdown. Barrett, who was known for her measured, judicial temperament, deviated from her customary restraint. "Miss Bondi," Barrett started, her voice ringing through the quiet courtroom. "Your constitutional argument flies in the face of established precedent in at least 3 landmark decisions. You might want to take a look at Harrington versus Davis before bringing such theories before this court." The tongue-lashing elicited polite winks and smiles from the rest of the justices. Bondi, leading a partisan group of states in this high-profile federalism case, quietly froze as Barrett went on with her unexpectedly blunt examination. "In addition, your Article 3 jurisdiction interpretation appears fundamentally flawed. I'm interested to know how you square this with your past legal work." What followed next shocked everyone in the room, including the normally stoic Barrett. In a matter of seconds, Bondi came back with a legal counter-analysis so dazzling and thoroughly researched that it not only shut down Barrett's criticism, but made the justice visibly rethink everything about the attorney before her. Before diving into this extraordinary legal showdown that has Washington's legal circles buzzing, don't forget to like this video and subscribe to our channel for more in-depth analysis of the high-stakes battles shaping America's legal landscape. Justice Amy Coney Barrett had risen to the nation's highest court through a combination of brilliant legal scholarship and steadfast conservative principles. Verified to the Supreme Court in October 2020, the erstwhile Notre Dame law professor and Seventh Circuit judge had rapidly gained a reputation as a strong jurist with a rigorous textualist interpretation of the Constitution. Famed for her biting questions at oral arguments, Barrett had gained respect even from across the aisle for intellectual ferocity and mastery of the law. Pamela Bondi had forged her reputation by another route. As Florida's first female attorney general from 2011 to 2019, Bondi had earned recognition for her tough prosecutorial approach and political savvy rather than academic legal theory. After her tenure, she had transitioned between private practice and political consulting, occasionally arguing high-profile cases but rarely before the Supreme Court. Her assignment as lead counsel in this momentous federalism case had set eyebrows among legal commentators who wondered if she had the constitutional acumen required for such complicated litigation. The case before the court, Federation of States versus Department of Commerce, had monumental implications. At stake was whether recent federal rules had invaded states' sovereignty on matters of taxation and land use unconstitutionally. The decision would potentially reconfigure the balance between the federal government and states for decades. For Barrett, the case was an opportunity to advance her originalist judicial philosophy in an era where the conservative majority on the court was becoming more inclined to overturn traditional precedents. She had spent much of her academic career studying federalism and saw this case as possibly landmark. Bondi, who acted on behalf of a coalition of 17 states protesting federal control, entered the case with alternate motivations. Having seen firsthand as Attorney General the impact federal regulation could have on state government, she possessed real-world experience that reinforced her arguments in court. She had been rehearsing for months for this hearing, knowing that skeptics questioned whether she was prepared to litigate such a case in the Supreme Court. The early exchanges had gone according to form until Barrett made her surprise challenge. Court watchers immediately knew this was a pivotal moment that could decide not just the fate of the case, but possibly Bondi's place in future constitutional litigation. Barrett's readiness to challenge directly Bondi's legal argument so early in the argument indicated that the justice had detected what she saw as essential vulnerabilities in the state's case. For Bondi, the stakes couldn't have been higher. A bad day would not only hurt the case, but prove critics who doubted her appointment as lead counsel. But under the calm exterior, Bondi had assets that Barrett had obviously not counted on, assets about to drastically alter the dynamic within the country's most influential courtroom. "Thank you for the question, Justice Barrett," Bondi responded, her tone unflinching in the face of direct criticism. Far from looking defensive, she reorganized her papers on the podium in a tranquil fashion. I'm well versed with Harrington, and, if I might, I'd like to set out why it in fact confirms instead of challenges our case. Barrett furrowed an eyebrow, the look on her face polite disbelief. Do go on. Harrington's central holding was based on a narrow reading of the Commerce Clause that Chief Justice Reynolds made unmistakably applicable only to situations in which federal regulatory interest demonstrably outweighs state sovereignty concerns. Bondi started, quoting the precise language without looking at notes. What's commonly underappreciated is Justice Kavanaugh's controlling concurrence, which set forth a three-part test for such situations. Barrett straightened slightly further, her eyes noticeably more alert as Bondi went on with precision to detail. Applying that test to our facts as they now stand makes plain an important difference. The challenged regulations in Harrington passed scrutiny because they satisfied all three requirements, most especially the third one, that federal action be calibrated to reduce unnecessary state administrative costs. Bondi then transitioned to a lesser-known case easily. This limitation was also explained in Westmoreland v. United States, where the court struck down federal regulations that did not meet this tailoring requirement, even as it recognized legitimate federal interests. Justice Sotomayor leaned forward. Counsel, Westmoreland was a fairly obscure Tenth Circuit decision, not Supreme Court precedent. Absolutely correct, Justice Sotomayor. Bondi shot back immediately. But then again, this court adopted Westmoreland's logic approvingly in footnote 23 of Montgomery v. Louisiana when dealing with the reach of federal regulatory power within spaces of state tradition. Barrett's look changed subtly, a combination of shock and recalculating. She didn't know that Bondi knew so many different layers to these cases. Also, Bondi went on, picking up steam, I'd like to respond to Justice Barrett's objection to my Article 3 jurisdiction argument by calling the court's attention to a too-seldom quoted passage in Justice Scalia's dissent in Williamson County. Although his view didn't prevail, his treatment of jurisdictional boundaries in federalism cases was later embraced by this court in Nick v. Township of Scott, essentially overruling the Williamson County majority position. Barrett interrupted, her voice now sincerely inquiring instead of scornful. You're implying that Nick's grasp of property rights is being held in the wider federalism context we're dealing with today? Yes, Justice Barrett, but not by mere analogy, Bondi answered. She went on to explain a refined legal theory linking Nick's argument to the case at hand through a chain of subsequent lower court rulings that had incrementally broadened its application outside the immediate context of property rights. The courtroom dynamic had changed. What started as a seemingly desperate effort to uncover flaws in Bondi's legal argument had turned into an elevated constitutional debate between two sharp legal minds. Other justices soon became more involved, with Justices Thomas and Kagan asking follow-up questions that Bondi answered with the same accuracy and depth. When Justice Alito inquired about a possible conflict with the court's recent decision in Texas v. Johnson, Bondi showed excellent memory by differentiating the cases on grounds so fine that a number of justices were seen referring to the case materials to confirm her claims. Miss Bondi, Barrett replied, coming back at the exchange with a distinctly changed tone, your application of these precedents is certainly innovative. But I worry that engrafting your interpretation onto us would entail our severely restricting our holding in Denison, which has served as a model for federal-state regulatory limits for almost a decade. The question was sophisticated and technical, exactly the kind of constitutional complexity that many had doubted Bondi could navigate effectively. The courtroom tensed with anticipation of her response. Justice Barrett, I have great respect for the Denison framework, Bondi started reflectively. But I would urge that applying Denison to these facts before us does not mean restricting its holding, but instead acknowledging its inherent limitations. Limitations which Justice Gorsuch himself recognized when he wrote for the majority. She then actually quoted Gorsuch's opinion directly. This framework sets general principles for routine assertions of federal regulatory power, while acknowledging that special circumstances will require more careful analysis. Bondi took a moment before stating her strongest argument to date. Our case involves exactly the sort of special circumstance Justice Gorsuch envisioned. One where federal rules technically meet Dennison's procedural requirements, but operationally remove state discretion in ways the framework never meant to authorize. The Chief Justice checked his watch and announced that Bondi's time was nearly expired. Rather than requesting an extension, a common practice in complex cases, Bondi efficiently summarized her remaining points with remarkable clarity, demonstrating complete command of her argument. As she was about to relinquish the podium, Barrett asked one last question. A hypothetical with conflicting state and federal interests, so complicated that law professors would go on to use it for constitutional law exams. The courtroom held its collective breath, believing that the convoluted hypothetical would finally reveal the limitations of Bondi's legal brilliance. What ensued would instead become one of the most talked-about legal exchanges in recent Supreme Court history. "That's a great hypothetical, Justice Barrett," Bondi replied, not skipping a beat. "It illustrates exactly the constitutional tension at the center of our case." Instead of providing a simplistic answer, Bondi systematically broke down the hypothetical, recognizing three different constitutional principles that would inform the analysis. With impressive accuracy, she quoted applicable precedents for each principle, including a few that Barrett herself had written while serving on the Seventh Circuit. In your 2018 opinion in Wisconsin Manufacturing Association v. EPA, Bondi observed, you wrote that when regulatory structures produce irreconcilable duties, courts have to consider which sovereign has